14-karat Quickie. You wouldn't think a living thing could be patented, would you? Well, not unless you were a Supreme Court justice. It started when GE bioengineer Ananda Chakrabarty developed a bacterium that could break down crude oil. GE filed a patent application and were turned down because, well, they tried to patent a living thing. And since there was absolutely no provision in the law for doing so, it couldn't be patented. But the United States Court of Customs and Patent Appeals overturned it, saying that since there was obviously no provision in the law for doing so, that meant that it could be patented. So in 1980, Patent Office Commissioner Sidney Diamond appealed to the Supreme Court, and the result was yet another insane 5-4 ruling. Not only did the court go against basic logic, they went against a 50-year-old precedent, Funk v. Kalo. The difference, they said, was that since the bacteria had evolved in a lab instead of nature, that means that GE had created it, and therefore it could qualify for a patent. I can only conclude they've been reading too many supervillain comic books. There's nothing stopping bacteria from naturally evolving to break down crude oil. And in fact, we've seen other species do just that with nylon and plastics. The whole idea of an invention is that it's something that couldn't happen in nature, not merely didn't. Diamond v. Chakrabarty changed that. 4 justices dissented. Not because the idea is completely insane, but because Congress didn't actually include it in the law. But it opened the door for big corporations to claim ownership of organisms that they'd modified even slightly, and also dramatically shifted the very concept of what could be patented, which previously had been anything specifically authorized by Congress, but now was basically anything Congress didn't think to exclude. Federal Appeals Court Judge Randall Rader later said, "This whole patent eligibility question, which was so clear and well defined, now has had a heavy cloud cast over it. The sad truth is that the Supreme Court has created a whole overlay of doctrine that makes the statute almost irrelevant. And now we don't look at whether there's a process, a machine, an article of manufacture, or a composition of matter. Instead, we look at whether there's something more beyond the conventional and the routine and the well-known." No one seems to have an answer for the question of what happens if a species of bacteria gains the same ability in nature? Is the natural bacteria patented? And if not, how would you tell the difference? What would be the difference? You know, it's nice when the Supreme Court actually thinks through their decisions. Unfortunately, that seems to be the exception, not the rule.